One may ask, what is a forensic accountant? Well, in the early days we were quite a rare breed. Our evidence was given usually orally, which means I had to appear at court very often. Since the 1999 civil procedure rules and then the criminal and family equivalents that came along shortly afterwards, it's become the custom for the expert to give their evidence in chief in a written report. So now it's far more regulated. I played my part in that change to more regulation because I served for 14 years on the Forensic Committee at the Institute of Chartered Accountants, where we helped to formulate a lot of this sort of thing. I've also written a lot of magazine articles, I've lectured, and I've helped wannabes who want to get going. Because it's all right being able to write expert reports. The challenge is that any case may end up at court, and so it's essential one has in mind that one might have to give evidence in court at this, and it's an extra skill. In effect, it's a second profession, being an expert, above one's basic profession of being a chartered accountant. What then is this concept of expert evidence? It goes right back to a 1783 case called Fulks and Chard, where John Smeaton was giving evidence on a matter of coastal erosion. You may recall that John Smeaton was the man who built the Eddystone Lighthouse, the first one they managed to get to stick on the rock. As he was giving his evidence, he was interrupted by opposing counsel who objected that Mr. Smeaton was expressing his opinions, giving judgment in the language of the time, on matters which he shouldn't, because that was the judge's job. The judge says, no, I have often relied on Mr. Smeaton's expertise in matters of such, whatever it happened to be, in this case coastal erosion, and these key words were then spoken. A man of science may express his judgment on matters within his own science. Within his own science is the key phrase. I as an accountant can't give evidence on cabbages or kings or even why the sea's boiling hot. But anything to do with accountancy, finance and their application to matters of law is within my own science, within my expertise. So courts rely on my opinions within those parameters. Let me give you an example, and it's nothing to do with accountancy, but no matter. In a recent very tragic case, Poppy and her granny were crossing the road on a pelican crossing. A car approached at very high speed. The light was red against it. The driver ploughed through. Granny was seriously injured. Poppy died. Anyone who'd seen that accident would be called a witness of fact, and that witness would be able to say, I was there, I saw the car, it was driving very quickly, the light was red, Granny and Poppy flew into the air, and the car then went into a wall and was smashed. However, an expert motor engineer would be able to come along afterwards and inspect the wreck of the car and say, in my opinion, the brakes had been working before the crash, the tyres were good, the weather was dry, the road surface was quite acceptable, and from the length of the skid marks, this is the thing, in my opinion, that car was driving at least 55 miles per hour and the speed limit was 30. Now, that evidence takes the court well on the way to convicting the driver of reckless driving if it's a criminal case, or of having to pay damages to Poppy's family if it's a civil case, because that man's qualifications, expertise and expert opinion can then be used by the jury or by the judge to make the decision. So one can see that my expert evidence can have a huge effect on the outcome of cases of all kinds. It can be how much an injured party would have earned for the rest of their life had they not been catastrophically injured. It could be how much the family would have received in dependency if the wage earner had not been killed. It could be, what is the value of the business, which, say, typically the husband is taking out of a marriage, which is to be balanced up with the house and the pensions or whatever that the wife is taking out of the marriage. It could be, in a proceeds of crime case, how much has the criminal benefited from this criminal conduct, and therefore what is the amount of funds that has to be forfeit to the state. The point is that Foulkes and Chard goes through a line of cases, Whitehouse and Jordan in 1980, the Icarian Reefer, and then into the Civil Procedure Rules at 35.3, which says it is the duty of the expert to assist the court within their expertise. So Foulkes and Chard talked about within his own science. The Civil Procedure Rules talk about within their expertise. It's exactly the same. We have a heavy responsibility to use our expertise as experts to assist the court to make what ought to be the right decision.